Honourable Senators, as you know, I proposed an amendment during the Senate Legal Committee study on Bill C-46, which removed the random alcohol testing provisions from this legislation. The vast majority of the legal experts that appeared before the committee testified the random alcohol testing provisions in this bill would be blatantly unconstitutional. My amendment passed with a majority vote of the Senate Legal and Constitutional Affairs Committee and was reported back to this chamber. The amendment Senator Gold is proposing today would have the effect of putting those unconstitutional random alcohol testing provisions back into Bill C-46. Senator Gold has based much of his belief that the random alcohol testing provisions will be seen as constitutional on the opinion of constitutional generalist Professor Peter Hogg, in a short brief that Professor Hogg prepared for the House of Commons Committee during their study of Bill C-46 last year. Prominent legal experts who appeared in front of the Senate Legal and Constitutional Affairs Committee effectively dismantled Professor Hogg's constitutional evaluation. Professor Don Stewart, a constitutional scholar specializing in the very matter of criminal law and the Charter, disagreed with Professor Hogg's assessment. Professor Stewart quite literally wrote the textbook on criminal law and the Charter that has been used to train thousands of Canadian lawyers. Stewart affirmed that random alcohol testing without the need for reasonable suspicion would contravene Section 8 of the Charter, the freedom from unreasonable search and seizure, and would not be saved by Section 1. Professor Stewart's brief declares that Professor Hogg's Section 8 analysis, quote, completely ignores the fundamental decision in Hunter v. Southam, which sets out a strong, purposive approach to Section 8 where there is a reasonable expectation of privacy. The Supreme Court has long held that a roadside breath demand engages such privacy protection, quote. Kyla Lee, a lawyer specializing in impaired driving cases in British Columbia, supported Stewart's evaluation that random alcohol testing in Bill C-46 would be found unconstitutional. She found that the random alcohol testing provisions in the legislation would not be found to be reasonable, minimally impairing, or proportionate. Bill C-46 creates a double standard of treatment for drug-impaired versus alcohol-impaired drivers. Why should alcohol-impaired drivers' charter rights be infringed while those of drug-impaired drivers are not? For this reason, Lee found that the random alcohol testing regime would in fact be found to be unreasonable. As for minimal impairment, or whether the law goes further than necessary, Lee wrote, quote, mandatory alcohol screening contemplated under Section 320.27 sub 2 is unnecessary at law. Peace officers are already equipped with the tools and training to compel roadside breath samples when it is reasonable to do so, quote. Furthermore, Lee found that that Bill C-46 would be disproportionate. I would like to directly address some of the comments that have been made in debate on this amendment so far. In his explanatory speech attempting to persuade this chamber about his amendment, Senator Gold often cited his own constitutional opinion, but noticeably, he did not refer to any witness testimony to support the constitutionality of the random alcohol testing provision other than, quote, the minister and government officials, quote. It's hardly surprising that the minister and government officials would take this position. I also found Senator Whetston's arguments to be rather curious, that we should pass this legislation with the random alcohol provisions intact so that the courts have an opportunity to rule them unconstitutional. Wouldn't we be better served by legislating to protect the charter rights of Canadians rather than saddling Canada's already overburdened court system with a decade of legal wrangling and challenges? As legislators, why would we vote to pass legislation in this chamber which has very clearly been shown to be of dubious constitutionality? As a chamber of legislative review, one of our first obligations should be to ensure that legislation we pass is constitutional. We should not neuter ourselves in this upper chamber of Parliament. Our job is to help create good legislation. After listening to the mountain of evidence we heard from legal witnesses at Legal and Constitutional Affairs Committee, I don't know how one would conclude that these random alcohol testing provisions could be constitutional. In my 5 years as a member of the Legal Committee, I have never heard a bill condemned so roundly as unconstitutional as Bill C-46, and yes, Senator Pratt, that includes 3 years of Conservative government legislation. Our committee heard grave unconstitutional concerns from representatives of the Canadian Bar Association, the Criminal Lawyers Association, the Civil Liberties Association, and the Canadian Council of Criminal Defence Lawyers, among others. Honourable Senators, we ignore these eminent legal voices at our peril. Senator Pratt devoted much of his speaking time to his research on conservative positions on impaired driving. You should proceed with caution, Senator Pratt. You might start to like conservative positions. In any case, Senator Pratt asked what changed between the time MP Stephen Blaney introduced his private member's bill, C-46, imposing random alcohol testing for impaired driving, to today. I can tell you what made the difference, Honourable Senators: the Jordan decision. This landmark case of the Supreme Court of Canada held that trials in lower court need to start within 18 months, while those in Superior Court must start within 30 months. Unreasonable delays beyond these limits could result in a stay, where charges and sometimes even convictions are dropped. In response to this ruling, scores of cases have been stayed already, including those of first-degree murder, rape, and serious assaults on children. Senator Pratt shared with us last night the poignant story of a family devastated by impaired driving to illustrate why he feels random breath testing is needed. But, Honourable Senators, among the multitude of cases thrown out by the courts for lengthy court delays exacerbated by unconstitutional random alcohol testing, there will be impaired driving cases by the hundreds, including cases where victims have been hurt or killed. Our Senate Legal and Constitutional Affairs Committee recently conducted an intensive 18-month study on the court delay crisis in Canada. Some of the independent senators had just been named to the Senate and to the committee near the end of that study. During our examination of the court delay issue, we frequently heard that impaired driving cases were, quote, clogging up court systems. We also discovered that impaired driving cases, on average, were among the longest to resolve due to their complexity, ranging from 105 to 127 days, and a whopping 227 days for drug-impaired driving. With charter challenges certain to increase under a random alcohol testing regime, it is inevitable that court delays would worsen as a result of its inclusion in Bill C-46. Senator Gold indicated that the only change random alcohol testing would be to remove the requirement for the police to have a reasonable suspicion a driver consumed alcohol before demanding a breath sample. This is a major change. In fact, Michael Bryant of the Canadian Civil Liberties Association testified at committee that, quote, "It is a huge shift in our criminal justice system. It is a warrantless search without cause and a warrantless seizure of our very breath and bodily fluids without cause. This is a dramatic departure from the way in which this country and our Charter of Rights and Freedoms have operated. It will now be a crime for an individual to refuse a warrantless, without cause seizure of their breath. It will be no defense that they didn't know about Bill C-46, quote. Of course, one of the primary concerns about including random alcohol testing is that it raises the potential risk of an increase in racial profiling. Adam Stephen Boney of the Canadian Council of Criminal Defence Lawyers testified, quote, "Our concern is that the random breath testing in Bill C-46, even if it is declared constitutional, will have the same impact and further widen the divide between the police and racialized and marginalized groups across the country, especially in communities like Toronto. This isn't just a theoretical argument," quote. Michael Bryant echoed these statements when he said, quote, "In the current context or the current era of racial profiling, carding, and the treatment of Indigenous people, which we will hear about later, it is an extremely sensitive issue. This is the worst time in which to be introducing anything that has the word mandatory in it when it comes to enforcement of the law," quote. Colleagues, when the government refers to this measure as mandatory alcohol screening, it is important to note that mandatory here means that the driver must comply with the breathalyzer demand, not that the police must test every driver they pull over. When Senator Jaffer asked Senator Gold a question during debate about how random alcohol testing would affect racial profiling, Senator Gold said, quote, "I don't have a great answer. This is a real problem," quote. Then he went on to say that if random alcohol testing is done in a vulnerable neighborhood, it may be racial profiling, but if it's done in a diverse neighborhood, it would not be. However, there is no requirement in this legislation that stops should only be established in diverse neighborhoods. And given the geographical and demographic realities of different regions of the country, that is not even practical. Instead, the Trudeau government's provision allows a breathalyzer demand from anyone, anytime, anywhere, without even requiring reasonable suspicion, a very low bar. Honourable Senators, we are the body of sober second thought. It is our duty to ensure our laws are the best they can be, not just good enough, in the face of overwhelming and compelling evidence to the contrary. This is especially so for the Senate Legal and Constitutional Affairs Committee, a body that is frequently quoted in Supreme Court of Canada judgments. As senators, we should not be shoving likely unconstitutional laws off to the courts. The profiling of vulnerable communities, the protracted legal battles, the compounding of court delays, and the victims of crime whose perpetrators walk free because of them are consequences that are much too dire. I hope you will join me in voting against this amendment from Senator Gold and for the protection of the rights of Canadians. Thank you.
Senator Batters, will you accept a question? Senator Gold.
Well, I regret that I wasn't able to ask my question of Senator Joyal to correct what I believe inadvertently was a mischaracterization of my speech and my disappointment that we weren't able to hear any witnesses, neither Professors Hogg, Solomon, or Chamberlain, nor of the mischaracterization of the law that the Globe and Mail managed to perpetrate. So my question, Senator Batters, to you is this. Would you not agree with the following statements of Justice Karakatsanis in the Goodwin case that, and I quote, "The compelling purpose of preventing death and serious injuries on public highways weighs heavily in favor of the reasonableness of the breath seizure, and, quote, the minimally intrusive character supports the reasonableness of the seizure, and further, that the proportionality test under Section 1, quote, does not require the government to adopt the least impairing measure, but rather one that falls within a range of reasonable alternatives." Thank you.
Senator Batters.
I don't have the familiarity that Senator Gold does with that particular case, but what I do return to is Professor Stewart's reasoning on that particular one. He referred to the Hunter v. Southern case. He also referred to the Godwin case, yet he came up with the assertion that random alcohol testing is a violation of Section 8, and random alcohol testing is not justified under Section 1 in his eminent opinion. As well, Professor Stewart also provided us with the very astute observation and something that Senator Gold referred to as an excellent soundbite, and it happens to also be true, is that in 35 years of charter jurisprudence, Section 8 for the Supreme Court of Canada has never been justified under Section 1.
Senator Gold, second question.
Thank you. Thank you, Senator Batters. You've relied in part on Professor Stewart's testimony and his very powerful statement. So my question is this. Given that in the 38 cases where the Supreme Court of Canada actually found an infringement of Section 8, Section 1 only figured in 6 of those cases. Given that one of those cases involved a search that was not prescribed by law, which mandatory screening would be, and given that 3 others involved the issues of lawyer-client privilege, where the court did not apply its basic balancing test, the standard test that it would apply in the case of mandatory alcohol screening, but instead incorporated the minimal impairment test from Section 1 into its Section 8 analysis, thereby rendering Section 1 superfluous, if not indeed redundant. Do you still believe that Professor Stewart's statement is particularly helpful in predicting how a court would rule on this issue?
Senator Batters.
I do. And it's bolstered by the fact of the significant Section 1 analysis that was done by Kyla Lee, which I also referred to in mine, and as well, Senator Gold, as you referred to and as Senator Joyal referred to in his argument, you have just confirmed that in 35 years of charter jurisprudence, the Supreme Court of Canada, in those 6 cases, has never found a Section 8 case to be justified under Section 1.
Senator Lankin, there's 27 seconds.
Gee, I could introduce myself and take 47 seconds. Senator Batters, there's been a lot of discussion in a number of people's testimonies about Section 8 and whether it could be saved by Section 1. I wanted to ask you about Mr. I think it's Edelson's testimony before the committee that raised the problem of Section 10B and the right to counsel, and if there were long lineups of people having
Senator, 5 minutes. Do you all agree, senators? 5 more minutes. Senator Batters.
It's also been something that several of the witnesses who testified before the Senate Legal and Constitutional Affairs Committee talked about. Some of them said not only is it likely a Section 8 violation, Section 9 just violation, Section 10B violation, that seemed to be the overwhelming position. In fact, there was one lawyer that just went on and on about all the different violations that could potentially occur, and yes, Section 10B was absolutely one of them, and I believe that that was Mr. Boney from the Canadian Council of Criminal Defence Lawyers.
To be fair, then, on the flip side, coming in at a question, as I'm trying to see and weigh a lot of different arguments, I mean, it is true that the Justice Department did a review of these provisions and came to an opinion and advised the government and the minister of that opinion, I'm assuming, in terms of how this bill was put together, and that there seems to be an international experience, not the same laws and charter, I get that, that supports this as one of the potential best practices. Can you comment on that from the flip side? I mean, do you have an inherent distrust of what justice says on these things, or how did you come to the conclusion that what they brought forward didn't really have any weight in your consideration of this issue?
Senator Batters.
I always have a lot of trust in what the Department of Justice officials bring forward, but it doesn't mean that we don't have the duty to properly question them, and many of the same officials were officials that worked for the department at a time frame when our Conservative government was in power. So, and some of them had actually put together the law that very closely mirrored this law, other than the random alcohol testing provisions. That part was totally new to the government legislation. But you know, when I sat there, I have just never in 5 years at that committee heard witness after witness after witness coming forward and saying it's unconstitutional for this reason, for this reason, for this reason. So, and frankly, when the minister came, we didn't get that much of a detailed justification in many ways. She just, you know, would refer to her charter statement, but her answers to questions, specifically about the things, the distinction between drug testing and alcohol testing, it didn't have a lot of weight to her pronouncements on that. And yes, also the jurisdictions that have random alcohol testing, Australia and New Zealand are two, they don't have a Charter of Rights and Freedoms, and that's a big distinction for Canada.
Sénatrice
Haguet. Question for Senator Batters. I've been listening to the ping pong game going on in this chamber between the people that have a brilliant legal mind, and I respect that. But as a non-legal brilliant mind, humble francophone from New Brunswick.
Oh, I love it. I love it. Yes. Lead on.
What my constituency wants to know is that when you refer to reasonable expectation of privacy for drivers, how can you balance that with the reasonable expectation of every citizen to be able to be on the roads, on safe roads, without drunk drivers killing them?
That is a huge concern for me too, and for the people of my province of Saskatchewan, and I know across the country. But what I want to make sure is that the people who deserve to get convicted of impaired driving and have serious consequences so that they aren't on the roads killing people, have those consequences, rather than have a potentially unconstitutional law create a decade of charter litigation that will create court delays that are so huge that we have cases where people who have driven impaired and have hurt or killed people, having their cases thrown out of court because their case took too long to go to trial. And frankly, also to have people who are charged with impaired driving who happen to be pulled over randomly but could have just as easily been pulled over because they were actually, the police had that low bar met of reasonable suspicion of impairment, giving those people a built-in constitutional defense to challenge it for years and have the victims of those crimes suffer through years of court delays because of it.